Welcome back everyone. Today I'm going to review The Case That Shook India by Prashant Bhushan. The Verdict That Led to the Emergency. Now this is a book that was written by Prashant Bhushan, who is also an advocate at the Honorable Supreme Court of India, and he was at that time a very junior counsel who was assisting his father, a senior counsel at that time, Mr. Shanti Bhushan. And because he was assisting his father, so he was very familiar with whatever was going on with this case. The name of this case is Indira Gandhi versus Raj Narayan. And this case was filed by Raj Narayan, who was contesting in Raebareli against Mrs. Indira Gandhi while she was the Prime Minister, and he was just a candidate in that Lok Sabha constituency, and he had lost that election against her. And at that time, he filed an election petition saying that she had done corrupt activities to win this election in this constituency against me, and that's why her election should be nullified and declared void. The name of the first chapter is From Election Battle to Court Battle. Now this is about elections that happened in India in 1971. She's contesting from Raebareli, and her main opponent is this person, Raj Narayan, who has filed this petition. She has filed her nomination papers, and one of her officer on special duty in PMO, Mr. Yashpal Kapoor, has resigned from his job so that he could become her election agent. Now the second chapter is about the petition. The election petition in the Honorable High Court of Allahabad has been filed because as per the law, the election petition has to be filed in the Honorable High Court, and then the Honorable High Court decides if any corrupt practice has been done, then the election is declared void. And this also results in a consequence that the person whose election has been declared void cannot hold any public office for the next 6 years. The name of the third chapter is The PM in Court. Now this chapter is about when Mrs. Gandhi had to come herself to the Honorable High Court and depose as a witness. And this is where she did a lot of mistakes, and you can read them in the book. Like for example, when the final judgment comes, the Honorable Court holds that she tried to mislead the court. And then there is this another officer who is a secretary level officer who is in charge of the PMO, and this person is PN Haskar. He also comes and deposes and tries to sanctify that this Mr. Yashpal Kapoor, who was an OSD in PMO, had already resigned on 13th of January, and he had accepted it orally. And then he says that and then the fact is that the Honorable President had accepted it only on 25th of January, and all of this becomes an issue because if the resignation had been accepted when it was given orally, then Mrs. Gandhi had not utilized his services. But if the resignation had become accepted when the Honorable President accepted it on 25th of January, then she was indeed guilty of taking the help of services of a civil servant in her election campaign. Now Mrs. Gandhi also came to the court. She came to the court on 17th of February 1971. She came to the court on 2 days. On the first day, she did well, but Mr. Shanti Bhushan told his friends on the evening of the first day that he had tried to make her comfortable, and now that she has walked into the trap, he will try to grill her on the second day. And that's exactly the thing that happened. On the second day, she actually walked into the trap and contradicted her own statements, and that also brought a stricture from the Honorable Court in the final judgment that she had indeed lied in the court. The fourth chapter is called The Petitioners' Opening Arguments, and the thing about this book is that the arguments in the book are very, very detailed and exhaustive, and that is the reason that it is not possible for me as well to talk about everything in this summary. But the thing is that there are some things that are at issue here. Now, Mr. Raj Narayan is the person who's challenged the election of Mrs. Gandhi, and he has contended some things that he is alleging against her. First of the things is that she has procured an Air Force plane for her election campaign. He says that she has taken the help of the state, of the government, which is not allowed under Representatives of People Act 1951. So because she had come to Lucknow via an Air Force plane, that's why he alleges that this is a corrupt practice. Another thing is that the argument that is made by Mrs. Gandhi's lawyers is that because it is given in the blue book, and because it is there is an administrative order which says that whenever the prime minister has to travel, the Air Force is duty bound to provide her with an Air Force plane, and that is the reason that she had not violated any law. But then the petitioners argue that a statutory law cannot be overridden by an administrative order. The statutory law says, which is that Representative of People's Act says, that she could not have taken the help of the state for her election campaign. The other issue is the of rostrums and speakers. So there is this stage that is set up by the DM of Raebareli and SP of Raebareli, and also there is this Union Home Secretary of UP, and these are all people of the state who are engaged as per the Blue Book, which says that wherever the Prime Minister travels, the district authorities have to make certain arrangements for law and order for the Honorable Prime Minister. Now this is also one thing that the petitioners argue is that is a corrupt practice, because other people are spending their own money on the erecting of rostrums and the installations of loudspeakers, but Mrs. Gandhi has enjoyed has done her election campaign on state's money. And then the another issue is of expenses. Expenses are regulated. Expenses on elections is regulated in India under Section 77 of Representatives of People Act, and they say that she came from Lucknow to Raebareli on 23 vehicles with 23 vehicles. They say that all of this should be counted in her election campaign's expenditure, because she has overreached her election budget. And there are so many other things, for example the installation of the loudspeakers and rostrums, which were in one way installed by the state, but because they were used by the for the election campaign, they have to be included in the expenses. So with this argument, they tried to prove in the Honorable Court that she had exceeded the limit that has been given under law, and that's why she has done a corrupt practice. Then there is issue of Yashpal Kapoor. Yashpal Kapoor had given oral resignation to Mr. Haskar on 13th of January, which was accepted by the Honorable President on 25th of January with retrospective effect from 14th of January. And because he was a gazetted officer, it was also printed in the Gazette that his resignation has been accepted. But the whole argument of the petitioners was that his resignation was accepted on 25th of January, and he, before the acceptance of the resignation, he had done services. He had given services to Mrs. Gandhi, and that's why she had taken help of a gazetted officer for an election campaign, and that is also a corrupt practice. Now there is the last issue is of religious symbol. Now Congress party's symbol used to be of a cow and a calf, and they said that it is a religious symbol because it appeals to a lot of Hindus, and that is one of the other corrupt practices that she has done by using the sentiments of the Hindus. Now while all of this was going on, in the 5th chapter the author talks about an amendment that is brought up. The amendment says that any kind of expenditure that is made by the party or another individual for the election prospects of a candidate will not be counted in the personal expenditure that is made by the candidate for the elections. Now this amendment is challenged and is argued on the behalf of the government by the Attorney General of India, Mr. Narain Day, and he defends the amendment by saying that it is a wrong argument to say that a democracy is protected when equality is protected, in the sense, because he argues that we cannot ensure by limiting the expenditure in the elections by merely saying that okay, this is the limit. For example, say 1 lakh is the limit. He says that if a beggar wants to contest an election, we don't even expect him to have 100 rupees. So he will, but there will be a middle class person who may have 1 lakh rupees to spare and spend for the elections, but there will be a very rich man who will have hundreds of crores to spare and spend for the elections. He says that this is a very, very, uh, vague argument to make, that a limit, the imposition of a limit for an election would be helpful in securing the democracy. Um, then the name of the sixth chapter is the PM's Council. Now, the PM's Council um, tries to, of course, defend her and says that this is a very, very malicious election petition that has been filed by disgruntled Mr. Raj Narayan to malign her. And he also talks about how this amendment is not a colorable legislation, and this is not merely being passed to protect the Honorable Prime Minister. And then he talks about how there have been many amendments that have been brought with retrospective effect. Now, one of the things about this amendment was that this amendment was affected with retrospective effect, which means that it said that even if some individual has spent money on a candidate even before the amendment was passed, then also it is all right. Now, this protected the Honorable Prime Minister in one sense, but her council, of course, said that this is, something that has already been done. This is not the only legislation passed by the Parliament that has a retrospective effect. Then, coming to the Air Force plane issue, he talks about how it is a part of the rule book. A rule book is about, you know a rule book is a book in which it is given very, very clearly the protocols that have to be followed when the Prime Minister is visiting, or the President is visiting, or some cabinet minister is visiting. It basically talks about how they have to be provided with planes and certain cars with security. Law and order situation has to be maintained, they have to be accommodated, and these are the things that are given in a rule book. So he argues that as per the rule book, the Prime Minister will always have to be provided with an Air Force plane when she is traveling. And it was not that she asked for it, but because it was an administrative compulsion because of the rule book, that she had to travel through a plane of the Air Force. And that's why he says that she, because has not herself ordered for it to be made available to her, she is not liable. Then when it comes to the issue of rostrums and loudspeakers, then he again comes to the rule book and talks about to the blue book, and talks about how as per the blue book, whenever the Prime Minister is touring a particular place, the DM and SP of that place have to ensure that the Prime Minister is provided with speakers, and stage is erected for so that the law and order situation can be maintained at that space. And says that for the same reason she is not liable for this as well. Then he talks about how even Mr. Raj Narayan, who was the opposing candidate, was also given 2 truckloads of policemen to maintain law and order situation in his rally. And he also talks about how some distinction has to be made when there is a rally of the Prime Minister and then there is a rally of an opposition leader who is not even like nationally established. Because he talks about how it is only justified to assume that a Prime Minister will draw far more crowds than another leader, and that is the reason he says that such rostrums and speakers were provided. Then coming to the issue of Yashpal Kapoor, he talks about how officer on special duty is not a permanent job in the government of India, it is a temporary job, and that is the reason that Mr. Haskar, as a principal secretary in the PMO, was very, very competent to accept the resignation of Mr. Kapoor as an OSD. And then he comes to the issue of expenses. He talks about uh, how, because it was provided for by the rule book, she is not liable for them. And also he talks about how, when the petitioners argue that 2 lakh have been spent on barricading, 1.8 lakh have been spent on 23 vehicles for her, and he argues that the petitioners do not really bring on any evidence to prove the expenses that have been made. For example, some like bill of the petrol station or something like that. Then coming to the issue of religious symbols, he says that it was allocated to her by the election commission, and it was not even her party's first choice. And because it has been allocated to her by the election commission, how can she be made liable and made to suffer for it? Then the 7th chapter is about the petitioner's rejoinder. Now the respondent has argued, the petitioners will do rebuttals. You can read this yourself. It is very, very complicated, thus cannot be summarized here. The 8th chapter is called the verdict. Now this is the verdict of the Honorable Allahabad High Court, and the judge who is hearing this case is Justice Sinha. Justice Sinha reveals later on that he was frequently visited by the Allahabad MP, and he became very, very irritated by it, and then he had to hide in his own house from 28th May to 7th of June so that he could write the judgment in peace. And no one was able to meet him, and he had told the people who were taking care of the house, except for him, that that they should tell the person, anybody who's coming to meet him, that he has gone to his brother's house in Ujjain. He delivered the judgment on 12th of June. Now there were Gujarat elections that had concluded on 11th of June, and the counting for the same was starting on 12th of June. So in this way, he kept the day of the judgment to be very neutral, so that the Gujarat results were not affected by it. Then the judgment of the Honorable High Court was that the petition was allowed, and election of Mrs. Indira Gandhi was set aside, and it was declared void. Now, but there is this twist. The thing is that the lawyers of the Prime Minister approached approached Justice Sinha and asked for 20 days stay order so that they could approach the Honorable Supreme Court, because it was also going to be making an unprecedented situation in the country wherein the Prime Minister was unseated, so alternative arrangements had to be made. But they also told a lie to Justice Sinha, that they had told Mr. Raj Narayan's lawyers, and they had agreed to it. Justice Sinha thought that maybe it was true, and he actually believed it. Not maybe, but he believed them, and he passed an ex parte order which said that this judgment would be stayed for 20 days, so that Mrs. Gandhi could approach the Honorable Supreme Court and get some remedy if possible. Then the offences, the corrupt practices for which the Honorable High Court found her guilty was that she had used Air Force plane, that she had used rostrums and speakers erected by the district officials who were government servants. Issue of holding out of elections, she had announced earlier, but she was saying that she had made a decision later on. So this also became an issue of contention. It is a little complicated, you can read in the book. Then she had the Honorable High Court also found that she had used the services of Mr. Yashpal Kapoor, who was an election agent, while he was a gazetted officer of the Government of India. And then the Honorable Court also held that she was giving inconsistent statements in the court. And then the court did not, although, find her guilty of using religious symbol and overreaching her expenses. Then the part 3 of the book is called the repercussions. Now this is this chapter talks about the rumblings that happened after the judgment, all of the issues. There were so many rallies that were conducted by the Congress. All of this, if you want to read about all of this in detail as to how emergency was imposed, please read the book, Emergency, A Personal History by Miss Kumi Kapoor, which also have summarized in this on this channel. I'll put a link to it. Then she talks. The author also talks about how just after the judgment was announced, she collected her legal advisors, which included Mr. Palkiwala, legendary lawyer, S.S. Ray, who was a good lawyer and also Chief Minister of West Bengal, and H.R. Gokhale, who was the Union Minister for Law. And then now this stay, which was granted by the Honorable High Court, meant that she could stay on, but there was also this moral obligation upon her to resign, because ultimately the Honorable High Court had found her guilty of corrupt practices. Now the appeal had been filed in the Honorable Supreme Court, and there was this statement that was made by Mr. Bhushan, the senior lawyer who was representing Mr. Sinha, Mr. Raj Narayan in the High Court. He said that she was unseated by the Honorable High Court at 10 a.m. when the judgment was pronounced. Then at that exact moment she was unseated, and because she could not stay as an MP, she could not stay on as PM, even if the condition that a person who's not an MP can be made Prime Minister, and then they have to get elected to either of the house within 6 months. He says that because 3 to 4 years had passed when that election had been concluded, she cannot stay on. And then he also talks about how at 10:30, when the ex parte order was passed, then she was reinstated, but she had already been unseated by the Honorable High Court. So he talks about how even if she wants to stay on, she will first have to accept that she has been unseated, and then she has to her fresh appointment has to be made, and then she has to take oath also again, because she has already been unseated by the Honorable High Court. Then all of this political frenzy has also spread out, which is about how the Congress President Mr. Barua has said that India is Indira and Indira is India. Then there are so many rallies that are happening by Congress and also the opposition. The name of the 10th chapter is the stay order. Now they have approached the Honorable Supreme Court, and she is asking for an absolute and unconditional stay from the Honorable Supreme Court, and the Supreme Court is on vacation. There is Justice Krishna Iyer, who is a vacation judge sitting on a vacation bench. He this chapter talks about how there is this precedent of the Honorable Supreme Court granting only conditional stay in such cases where elections have been declared as void because of corrupt practices by the Honorable High Courts. Now she is asking for absolute and unconditional stay. Mr. Raj Narayan's counsel is opposing it, and they say that if at all it has to be given, it has to be a conditional stay. And what does conditional mean? That they remain a member of parliament, but they cannot attend the proceedings of the house, and they cannot vote inside the house. Now this deprives them of voting rights and also participation in proceedings of house. Now Palkiwala argues that because such a case of the Prime Minister has never arisen, it would be prudent that the Honorable High Court, the Honorable Supreme Court grants an unconditional and absolute stay. But he also talks about how these offences are absolutely technical. There was no clarity about these offences, and she is the Prime Minister. If the Prime Minister goes somewhere, there have to be arrangements that will be made. There will always be one or two issues. Now there is this one very interesting line in the book, which was, I think, published in some newspaper of the UK, which is that it is like dethroning Queen Elizabeth for jumping a red light. So this was compared to that this was such a minor offense, such a technical offense, and dethroning her, unseating her from the seat of the Prime Minister of India for doing just this would be like something like that. Then Bhushan Senior Counsel argues that even if these offences are technical, these are still offences, and because she has been declared, her election has been declared void, she has to go. Then um, he also talks about how a person who's under cloud cannot be allowed to carry on as the Prime Minister of India. The Supreme Court delivered its judgment on 24th of June and gave a conditional stay as per the precedent. It meant that she could stay on as the Prime Minister. It was clearly mentioned in the judgment that she could stay on as the Prime Minister, but also it meant that she could go to the Parliament, but she could not vote. But she could not vote. Um, then the name of the 11th chapter is Law. What law? Now this is about how just after this conditional stay is granted, within 1 or 2 days the emergency is imposed, I think on the same day or the same night of that. And then on August 4th there is this amendment which is introduced, which talks about how if a prime minister goes somewhere and there is this administrative order which says that she has to be treated in some manner. For example, rostrums and loudspeakers have to be provided and barricading has to be made for that. Such arrangements have to be made by the administrative orders, and it is not an uh, offense under election law. So in this way, she had taken advantage, or she has overturned the judgment of the, not overturned, but she has actually secured herself by ensuring that the offences for which she was found guilty, that she had taken services of DM and SP of Raebareli, and that Yashpal Kapoor was in her service while he was there in the election process. So she has in a way tried to evade that. Then she is also trying to get away with using Air Force plane while she was on her election rallies. Then there was this another amendment which was made on 7th of August. This amendment said that any dispute arising out of election of president, vice president, election, speaker or prime minister would no more be decided by the High Court, but there would be a special forum which would be formed by the Parliament, which would decide on these issues. Now, it also said that if any such decision has been made by the High Courts in past, then that would also be void, and it meant that she had now ultimately voided the High Court judgment through Parliament, and she was now no longer guilty of any offence, because now the High Court was not even a forum where election petition was to be decided, and she brought it with a retrospective effect. Now this amendment itself, which was 39th amendment, was challenged before the Honorable Supreme Court, and the 5 senior most judges of the Honorable Supreme Court, including the Chief Justice, started to hear this case. Now these amendments also seriously jeopardized the case of Mr. Raj Narayan, and her lawyer now was Mr. Ashok Sen, and he submitted that Parliament had clarified the law, and because it stood clarified now, Mrs. Gandhi was not guilty of committing any offence anymore, because already there was this argument that these are very very technical offences, and she should not be punished for these technical offences. But the lawyers of Mr. Raj Narayan, Mr. Bhushan, challenged 39th constitutional amendment. He argued that no constitutional amendment could be made which violated the basic structure of the Constitution of India, and he quoted extensively from Keshwanand Bharati, wherein 7 judges had held that the basic structure cannot be touched. Now also he talks about, because because this amendment takes away the right of judicial review in such cases, it should be declared null and void, because judicial review is part of the basic structure. And then he also talks about how it also violated equality by differentiating between the Prime Minister and another MPs, whereas other MPs had to go to MPs or even Cabinet Minister would have to go to the High Court. The forum for the Prime Minister was to be decided by the Parliament. Then the book comes to part fourth. Then the it is named as Validity of the Constitutional Amendment. 12th chapter is named as It Destroys Democracy. Now, Mr. Sain is the lawyer of the Prime Minister, and he argues that the government and the Parliament wanted to avoid embarrassment to the judiciary, and that's why they had clarified the law and also held the judiciary in a way so that they would not have to make this very very tough decision whether to unseat the Prime Minister or not. Then Mr. Bhushan comes on. He says that it is not a constitutional amendment at all, and if at all it is a constitutional amendment, then it violates the basic structure of the constitution and thus has to be declared null and void. Then he also talks about how the session which has passed this constitutional amendment is illegal because most of the opposition MPs are in jails by the government. He says that if these MPs are in jail by the government, then tomorrow any kind of law will be passed by the Parliament. And then he says that because most of the opposition MPs are in the jails, it is an illegal session of the Parliament. And this was a very very sensationalizing argument which was being made by him. And but Mr. Bhushan reveals that he added it to his arguments so that he could pressurize the judges so that he could take this case seriously. Then he talks about how Parliament, by passing this amendment, is carrying out a judicial function and using judicial powers which is not even given to them. That is, that they have nullified the effect of the judgment of the Honorable High Court, which they could not have done. And then it also talks about how Article 368 gives amending power to the Parliament and not the judicial powers. Because in one way they were taking away the powers of the judiciary to hear election petitions. Then he also vehemently argued that it violates basic structure, and because judicial review is eliminated, it violates basic structure and equality is denied, and that rule of law is also being compromised by this amendment. And also the fact that he argued that this session in itself is illegal, and that's why this law being passed by the session in itself becomes illegal and null and void. Then the 13th chapter is named as PM can be above the law, and this is argued by Attorney General, who is Mr. Nirinde. He argues that election disputes have always been the domain of the legislature in most of the countries, and because of that reason it is not a very very wrong thing for the Parliament to take back that power with the legislature and decide on election petitions. He also talks about how Prime Minister and speakers being placed on a different pedestal is only justified because they carry out very very important functions for the country, and they are also holding very high offices. Then he talks about how judicial review of election petitions was never a part of the basic structure, so basic structure is certainly not destroyed, and amendment was exercise of judicial power and not of legislature power and not judicial powers. Now maybe I'm just reading out these arguments, but if you want to understand these arguments clearly and with some more wisdom, then please read the whole book. Then he also talks about how the legality of the session cannot be questioned by the judiciary because the constitution prohibits judiciary from interfering in the functioning of the house. Then the 14th chapter is named as Amendment is like a Firman. Now Solicitor General Sinha is arguing for the Union of India, and he makes very bad and vague arguments which I honestly literally can't understand, which do not even cut eyes with the judges, and they are literally shattered when judges ask him questions. Now 15th chapter is titled as Emergency Measure or tranquilizer. Now in this chapter, the rejoinders are, you know, made by both the parties, and this is also very minute chapter with very minute details, so you can read it in the book. Now part fifth of the book is titled as Validity of the election law amendments. Now Mr. Bhushan is arguing, and he argues that rule of the games have been changed by the parliament by giving it retrospective effect. But and then he says that a very wise and just judgment was delivered by the Honorable High Court, which has now been nullified. And he also argues as to how official duties only include statutory duties. It does not include the orders that have been given by a minister. For example, he argues that if official duties also include the orders given by the minister, then a minister can order his secretary to help him in his election campaign, and that would not be legal, which is certainly illegal. So he says that the duties that have been given to the government of India officials through through statutes should be considered their official duties, and anything else that they do to help the ministers in winning the elections should be considered as a corrupt practice. Then chapter 17th is titled as Rules Not Changed, Merely Clarified. Now this is the rebuttal to the to Mr. Bhushan's complaint that rules of the game have been changed retrospectively, and Mr. Sinha is replying to Mr. Bhushan, and he says that official duties would include arrangements for VIPs and law and order situations have to be maintained, and also because of the blue book obligates these officials to do so. Then he also talks about the amendment clarifying the rule, the date of resignation part, that the resignation would deem to be accepted on the day when the president says it is accepted. So that part also of Mr. Yashpal Kapoor helping her in the elections even when his resignation was not yet accepted by the president was also out of the way now. Then coming to the symbols of religious symbols of the party, he says that it was election commission which gave her the symbol and she cannot be made to suffer for the same. And then he talks about how these amendments do not change law, and they do not change the rule of the game, they merely just clarifies the rules after the game has been concluded. Coming to the expenses part, he says that according to the amendment, officials making arrangements cannot be included in the expenses. So that's why her expenses, which the Honorable Judge of the High Court has included for 16,000 for rostrums and 1900 for loudspeakers, should not be included, and that is the reason that her expenses have in no way in no way breached the limit that has been imposed by the law. Then the amendment also clarified on symbols. It says that if the election commission has given some symbol by religions which is a religious symbol, then the candidate cannot be made to suffer for the same. Then the 18th chapter is called Parliament Can't Interpret the Law. Now in this it is vehemently argued by Mr. Bhushan that how Parliament is to legislate and not to interpret. Interpretation of the laws is the sole reservoir of the judiciary. He also tries to instigate the judges to show them that something that was their reservoir, their reserved jurisdiction has been taken over by the parliament in this. Now 19th chapter is about the Supreme Court judgment in this case. Now by majority it has been held that this constitutional amendment has been struck down, but election laws have been upheld, which meant that she is no longer guilty of any electoral fraud or offense, and now she can easily carry on as a Prime Minister of India. Now the 20th chapter is called the epilogue. From court battle to electoral battle, all this happened during the emergency, and this chapter talks about also ADM Jabalpur. This also reminds us of the horrors of the emergency. Very short chapter. Now overall this book is extremely difficult to read. If you are not a lawyer, because the arguments are extremely complex. There have been times when I have read an argument 5 times over again and still not been able to understand it. But overall, the book is extremely interesting. It makes you think a lot, because the arguments are so complex that you actually start to think as a lawyer should think, and make arguments of that level which the senior counsels make. The background of the case is so interesting. It involves the prime minister, how she is unseated, and then there was this political drama, and how sometimes even judges, there is pressure on the judges, um, to decide the case in a certain way. uh, the author, because he was himself involved personally in this case, talks about the strategies that were adopted by by the lawyer, by the senior lawyers in the case. So it is actually interesting, but a little difficult to follow book. So if you are a lawyer, I would absolutely recommend you to read this book. But if you are no, a person from the non-law background, maybe you will find it difficult to follow. But otherwise, it's a great book to read. Um, Thank you very much for listening to me. Please subscribe, and take care. Stay safe. Thank you.